All right, guys, so awesome. You've taken the step to learn how to do surplus funds in Florida. And the first place where we're going to start is learning the state statutes for the tax overage and mortgage foreclosure sales, okay? We want to make sure that if we are representing somebody to assist them on filing a claim, we know exactly what we're doing and we're in the correct guidelines of doing this legally, okay? So in today's video, I am going to explain to you the mortgage foreclosure and tax sale law in reference to surplus funds in Florida. You guys are going to have the links to the state statutes. I'm also going to explain how we need to use this link in reference when we're sending out our intro email. I'm going to go over the fee percentage that you can charge in Florida for both tax overages, mortgage foreclosures, and then go over the cap explanation, all right? So let's go ahead and start with the tax overage statute. All right, so we're gonna click here, we're gonna open this up. So here, this statute is the disbursement of proceeds of sale in reference to tax sales and tax liens, okay? Now, Florida, the way that it works is, initially there's a tax lien certificate, okay? Meaning that somebody purchases a certificate and then they get a lien placed on the property and the amount of taxes that were due. The previous owner, if they want to complete that tax lien, pay it off, they would have to pay the taxes owed plus interest, all right? And then if they do that, the investor who purchased the tax lien certificate gets their money and the interest. Now, if that does not happen and the property goes to sell, what's gonna happen is this is gonna turn into a tax deed sale. So now at a tax deed sale, the property is gonna be auctioned and it's gonna sell for a higher amount. Once it sells for a higher amount, the opening bid is going to be the taxes that were due plus interest and any other cost to initiate the foreclosure. So the tax lien certificate holder is gonna get their money back, all right? Now there's gonna be a third party purchaser who purchased the property and there's gonna be a surplus, all right? So this statute is in reference to the disbursement of the proceeds after the sale, okay? So it says here, if the property is purchased by any person other than the certificate holder, the clerk shall forthwith pay to the certificate holder all of the sums he or she has paid, including the amount required for the redemption of the certificate of certificates together with any and all subsequent unpaid taxes plus the costs and expenses of the application for the deed with interest on the total of the such of sums in the period running from a month after the date of the application for the deed through the month of the sale at the rate of 1.5% each month. Okay, so that's basically reiterating what I mentioned, how it starts off at a tax lien certificate. The certificate holder, if it's purchased by somebody other than the holder, they're going to pay that lien certificate holder, and then that includes interest. All right, so that's what that's talking about. Now it says that if the property is purchased for an amount in excess of the statutory bid of the certificate holder, the statutory bid of the certificate holder is going to be the amount of taxes plus interest and the cost to have the foreclosure. The surplus must be paid over and dispersed by the clerk as set forth in the section above. All right, if the opening bid included the homestead assessment, all right, that amount must be treated as surplus and distributed in the same manner. All right, so they should disperse the surplus to governmental units for the payment of liens recorded. So if there's any governmental liens that are recorded on the property, they're going to pay that. All right, if there is a balance that is remaining, it's going to be retained by the clerk for the benefit of the persons described in section right here. All right, so basically this is going to be the previous owner, heirs, and lien holders who are going to be qualified those funds. All right, so if we click here, that's going to be the owner, and then we have that information, and then also lien holders as well. All right, so we have here the notice of surplus funds. This is going to be a document that the county sends out. All right, they also are supposed to be sending out the claim form. So the previous owner is supposed to get notified that there is a surplus, and then they're supposed to get a claim form. But not every county is nice enough to do this, or some individuals don't receive it because the county sends to the address that was just foreclosed. Okay, so when it comes to a tax sale, counties will have information. Like this is Lee County. They have the information, tax deed surplus. They have here the checklist to claim the funds if you're a surviving spouse, if you're doing assignment of interest, and then they actually have the claim form. All right, so Florida is very transparent, very simple. They give you the claim form and they tell you. So in Florida, guys, for tax deed surpluses, we do not need to use an attorney, and also there is no cap on how much we can charge. Okay, this is only for the tax sale. So you can see here, they give you the claim form, they even give you the checklist, they give you the instructions on how to actually submit a valid claim. Most counties have this. If you can't find it, give them a call, give them an email. But in Florida, you do not need an attorney to have a successful claim. There's going to be times where you will need to use an attorney on the tax deed side, such as probate scenarios where the deceased individual, the previous owner is now deceased individual, or if a claim is going to go to interpleader, there's multiple owners and there's no clear-cut answer. The county, when it's an interpleader, their counsel may want to speak directly to an attorney. All right, so it's highly recommended. If you have a clear-cut case where you have the previous owner, go ahead and file it by yourself. If you need the assistance of an attorney, this course does. In the reference section, I have an attorney that is more than happy to help you out. All right, so that's for the tax deed side. Okay, one thing we need to keep in mind on the tax deed side, there is a 120-day redemption period. Not redemption period, sorry, 120-day period in which the claim has to be submitted for lien holders, and then after that 120-day period has passed, lien holders have no rights towards the claim, only the previous owner. This also means that the county will not review any claims within that 120-day period. Okay, that doesn't mean we're not going to submit a claim. It just means they won't review it. So we can definitely submit it, and I advise you to get a client under contract and submit it as soon as possible to avoid any other company trying to swoop in and take over your hard work. All right, so once that property has been sold at the tax sale and they've given out the notice of tax deed surplus, the 120-day ticker starts. You want to get the client under contract, you want to submit the claim. If the lien holders do not file a claim within that 120-day period, even if there is a lien that can take over the surplus, they have no rights. Only the previous owner does. All right, so that's the 120-day stipulation in Florida. All right, so keep that in mind. Now, let's go ahead and go over the mortgage foreclosure statute. All right, now this is going to be the mortgage foreclosure sale, which is going to be different than the tax sale. All right, so at the mortgage foreclosure sale, this is going to be for either somebody not paying their mortgage or somebody that's not paying their HOA fee. Sometimes you might even see a timeshare. All right, so we have here disbursement of surplus funds after a judicial sale. Florida is a judicial sale, meaning that it's handled by the county. All right, non-judicial means it's managed by a trustee. Okay, so we have here, and the final judgment is basically going to be the amount that was owed plus any additional cost and interest to actually have the foreclosure. All right, now if the property is sold, there may be additional money from the sale after payment to persons who are entitled to be paid from the sale proceeds pursuant to the final judgment. Okay, if you're a lien holder after the sale, you must file a claim with the clerk no later than the date that the clerk reports the funds as unclaimed. If you fail to file the timely claim, you will not be entitled to remaining funds, but the previous owner, you will. All right, you may claim these funds yourself. You're not required to have a lawyer. They say that, but people don't even know about it. Okay, so in Florida, the way that we're going to work mortgage foreclosures is the defendant that is listed is going to be the parties that are eligible to receive the surplus funds. Now, if that defendant has passed away, then the heirs are eligible. All right, so you will always be able to see this is going to be the parties that were listed in the case when the foreclosure occurs. So if somebody does a quick claim deed, tries to transfer it before that property is actually foreclosed, that doesn't matter on the mortgage foreclosure side. The previous owner, the defendant listed in that case, is going to be entitled to surplus funds. Now, in the tax detail, it's going to be different. So that's one thing to keep in mind. All right, so if you talk to somebody and they say, oh, I did a quick claim deed, they're still going to be entitled to those funds. All right, because it says here only the owner of record as of the date of the lis pendis may claim the surplus. Lis pendis is going to be that final judgment. Okay, so that's that. Now, in Florida, there is that 12% stipulation if you are going after this as an assignment of interest. Okay, so what I recommend is you can use an attorney. The attorney will submit the claim, receive payment, and then will pay you out. The county will have no idea what you charge. Okay. If you are doing assignment of interest, you're going to be capped at 12%. There's nothing wrong with that. A lot of big companies do this. You can do volume with your 12%. It says it right here: the total compensation paid or payable or earned or expected to be earned by the transfer or assignee does not exceed 12% of the surplus. Okay. So they're saying if you're doing the voluntary assignment, this is the information that needs to come in: seller assignment of rights to the surplus funds. All right, clerk fees, all this other good stuff. So basically, guys, we know that the surplus funds are going to be available. We're going to be able to see that by reading the certificate of disbursement. So check out my other video where I'm going to explain how you guys can do your due diligence, check for proof, check to see if a claim has been submitted. But understand that mortgage foreclosures, if you do not do assignment of interest, you can charge whatever you want. There's no cap. If you do assignment of interest, you're capped at 12%. Understand that lien holders have a small time frame to submit the claim. Understand that the previous owner, as long as the county still has the funds, can also go after them. All right. Now, with mortgage foreclosures, I'm going to give you guys videos on how to do research for tax deed and mortgage. It's very important that you understand how to read those dockets so that you can go on the county site and do your research on the case information and you can have valid claims. All right, guys. So hopefully this video was great. I went ahead and I broke down the state statute for tax overages, for mortgage foreclosures, and I went over the percentage cap. So hopefully you guys are going to take this information, apply it, and get a deal done.